Calls for increased oversight. Calls for increased oversight have emerged as a prominent feature of the reform movements aimed at recalibrating the balance that the Peace Officer Bill of Rights has historically struck between protecting officer rights and ensuring accountability. As public scrutiny intensifies following high-profile cases of police misconduct, policymakers, civil rights organizations, legal scholars, and community advocates are advocating for structural changes that enhance transparency, elevate independent review, and fortify mechanisms for meaningful scrutiny of law enforcement agencies. These proposals do not seek merely to dismantle POBR protections. Rather, they aspire to refine them, ensuring that procedural safeguards for officers coexist with robust oversight that can deter misconduct, restore public trust, and ultimately strengthen the legitimacy of policing in a democratic society. One of the central reform themes is the creation or empowerment of independent oversight entities. Historically, internal affairs units have borne much of the responsibility for investigating misconduct allegations, but critics argue that such units may not always operate at sufficient distance from the officers they investigate. To address this concern, reform proposals frequently call for establishing independent review boards or strengthening existing civilian oversight agencies. These bodies, insulated from departmental hierarchies and union pressures, can conduct unbiased investigations, issue recommendations for discipline, and provide public reports that enhance transparency. By transferring some investigative authority away from departments and toward independent entities, reformers believe they can reduce the appearance or reality of institutional bias in adjudicating misconduct claims. Such independent bodies could also ensure that POBR provisions do not become insurmountable barriers to accountability. While POBR may set timelines, disclosure limits, and procedural steps, an empowered civilian oversight board with legal authority to access documents, subpoena witnesses, and review disciplinary decisions can help navigate these constraints. By serving as a neutral interpreter of procedural rules, the oversight entity can prevent POBR requirements from devolving into obfuscation and ensure that factual information is not overly concealed. Reform advocates point out that several jurisdictions have already begun to experiment with granting civilian review boards more extensive powers, including subpoena authority and the right to publish findings, thereby illuminating patterns of misconduct that might otherwise remain hidden. Another strategy aimed at increasing oversight involves legislative reforms that adjust POBR statutes themselves. Policymakers in some states have pushed for amendments to remove or lessen confidentiality provisions, shorten procedural timelines that impede timely investigations, and clarify conditions under which records must be disclosed. For example, in Maryland, the birthplace of a law enforcement officer's Bill of Rights, recent reforms have effectively repealed and replaced its original LIABR with new laws intended to enhance public access to disciplinary records and establish more transparent investigative protocols. Similarly, California, historically known for strict confidentiality rules, passed Senate Bill 1421 in 2018, granting the public limited access to certain police misconduct and use of force records. Although not a direct overhaul of POBR, such legislative changes reflect a broader trend. Policymakers are using statutory adjustments to ensure that oversight bodies, journalists, defense attorneys, and civil society groups can access the data they need to scrutinize police behavior. In addition to legislative reforms, some reform movements encourage the adoption of standardized data collection and reporting practices. Calls for increased oversight emphasize that transparency depends on accurate, consistent information. Proposals suggest that departments be mandated to maintain comprehensive, searchable databases of misconduct complaints, disciplinary actions, and outcomes of internal investigations. Such databases would ideally be accessible to oversight entities and, in some form, to the public and press. The logic is straightforward. Robust oversight requires reliable information. When advocates can track complaint patterns, identify repeat offenders, and correlate certain types of misconduct with specific units or shifts, they can direct oversight efforts more effectively. This data-driven approach also supports evidence-based policymaking, enabling legislators and department leaders to understand whether reforms are yielding tangible improvements over time. Beyond structural and legislative changes, reform movements have proposed increasing oversight through judicial clarification and precedent. Courts can play a crucial role by interpreting POBR provisions in ways that prioritize transparency and accountability. For example, when courts review challenges to disclosure requirements or assess the constitutionality of certain POBR protections, their decisions can set precedents that either reinforce or curtail secretive practices. Over time, judicial rulings might define clear boundaries around what must be disclosed to prosecutors, defense counsel, or oversight boards, thereby weakening arguments that POBR mandates absolute confidentiality. Moreover, court orders compelling departments to release documents or permit civilian oversight bodies to review cases send a strong signal that POBR laws cannot be invoked as an all-purpose shield against public scrutiny. Reformers also argue that effective oversight requires cultural shifts within law enforcement agencies. While structural changes and legal mandates can open doors, the willingness of officers, supervisors, and union leaders to embrace transparency is critical. Training programs that emphasize accountability, procedural justice, and community engagement can reorient the internal culture of policing. Increased oversight is not meant to be adversarial by default. Instead, reformers contend that it can ultimately enhance professional standards, encourage best practices, and differentiate the vast majority of honest, hard-working officers from the minority who commit misconduct. When departments accept the legitimacy of oversight and actively participate in continuous improvement processes, they can reduce resistance to external scrutiny and proactively identify areas for reform before crises occur. Closely related to these calls is the push for public input and community representation within oversight structures. Advocates for increased oversight contend that communities most affected by policing should have a voice in how accountability frameworks are designed and implemented. This might involve granting civilian board seats to local stakeholders, organizing town halls to solicit public feedback on proposed reforms, or partnering with civil rights organizations to monitor the implementation of new laws. The idea is that authentic community participation can help ensure that reforms align with local values, address specific concerns, and build trust between law enforcement and residents. By democratizing oversight, reformers hope to prevent technocratic or politically driven approaches from overshadowing the lived experiences of those who interact with police officers most frequently. While many of these proposals have garnered support, law enforcement advocates sometimes raise concerns about the potential costs and consequences of increased oversight. They argue that without careful calibration, expanded oversight authorities might deter capable recruits from joining the force, create overly adversarial environments, or subject officers to harassment and frivolous complaints. In response, reformers emphasize that the goal is not to harass officers, but to ensure that accountability processes are fair, credible, and accessible. They maintain that well-structured oversight can bolster public confidence, ultimately making officers' jobs safer and more effective by reinforcing community cooperation and respect. In a political landscape often shaped by high-profile incidents, public sentiment toward policing can evolve quickly. Reform movements understand that the window for structural change may appear in the aftermath of controversial cases, and thus they strive to present coherent, actionable proposals to legislators and policymakers. Some states have formed special commissions to review their POBR laws, inviting testimony from legal experts, civil rights organizations, police unions, and community leaders. These commissions often produce reports that become blueprints for incremental, consensus-driven reforms. Although change is rarely swift or uniform across jurisdictions, the cumulative effect of these conversations can shift the baseline expectations for what constitutes adequate oversight and transparency. Looking forward, the calls for increased oversight reflect a broader reimagining of police accountability. They present POBR not as an immutable barrier, but as a set of protections that can and should be recalibrated in light of evolving legal standards, public opinion, and empirical evidence about what strategies effectively deter misconduct. Oversight, according to reform advocates, is not merely an external check on policing. It is a critical component of a healthy policing ecosystem that affirms the rule of law, upholds constitutional rights, and fosters community trust. Without meaningful oversight, reforms argue, the justice system risks legitimizing opaque procedures that fuel discontent and suspicion. With it, they see an opportunity to harmonize the objectives of officer protection and public accountability, ultimately strengthening the institution of policing. In sum, calls for increased oversight represent an integral strand in the tapestry of POBR reform movements. Through independent review boards, legislative amendments, data-driven transparency, judicial interpretation, cultural transformation within departments, and inclusive policymaking processes, advocates endeavor to ensure that procedural safeguards do not come at the expense of the accountability necessary for equitable, trustworthy law enforcement. As these reforms unfold, they will undoubtedly continue to shape the contours of police accountability, challenging conventional assumptions and forging a more transparent future. Legislative changes and reforms. Efforts to reform the Peace Officer Bill of Rights, POBR, frameworks have increasingly focused on legislative changes. Proponents of reform argue that legal statutes are not etched in stone. Rather, they can and should evolve to reflect new realities, public expectations, and empirical research regarding effective accountability measures. Through targeted amendments, repeals, or overhauls, lawmakers have sought to reconcile the need to protect officers' procedural rights with the imperative of ensuring transparency, accountability, and public trust. These legislative reforms, often informed by academic studies, advocacy efforts, and lessons learned from other jurisdictions, aim to recalibrate the legal structures that have governed policing for decades. A central legislative trend involves the partial dismantling of strict confidentiality rules that POBR laws have long imposed on records related to police misconduct and disciplinary proceedings. Historically, state statutes often shielded personnel files, internal investigation reports, and disciplinary outcomes from public view, making it difficult for community members, journalists, and even prosecutors to access information about officer behavior. In recent years, reform advocates have pressed legislators to narrow these confidentiality provisions. For instance, California's Senate Bill 1421/2018 opened certain categories of police records, such as those involving shootings, sexual assault, or proven dishonesty, to public scrutiny. By enabling limited transparency, these reforms seek to ensure that serious misconduct cannot be quietly tucked away behind statutory barriers, allowing oversight bodies, the media, and the public to engage more meaningfully in the accountability process. Such legislative changes have not come without resistance. Police unions and some law enforcement advocates have argued that diminishing confidentiality may encourage unfair public vilification of officers, complicate hiring and retention, and potentially deter qualified candidates. Nonetheless, reform proponents counter that narrowly tailored disclosure requirements need not expose every detail of an officer's record. Instead, they can focus on patterns of egregious misconduct, thereby ensuring that serious offenses are not concealed. Lawmakers who embrace these arguments often frame transparency not as a punitive measure, but as a necessary ingredient for building trust and empowering communities to hold agencies accountable. Another legislative approach involves refining the procedural timelines and investigative constraints that POBR statutes impose. Under many existing frameworks, strict deadlines can force departments to conclude investigations prematurely or allow cases to languish if certain milestones are not met. Some reform bills propose more flexible timelines that grant investigators the latitude to gather comprehensive evidence without undue haste. Alternatively, they may tighten deadlines in a manner that ensures accountability by preventing drawn-out investigations that lose momentum over time. The goal is to strike a balance that acknowledges the complexity of misconduct inquiries while preventing procedural technicalities from undermining the thoroughness and integrity of the investigative process. The American Civil Liberties Union, ACLU, and other organizations have supported legislative measures that ensure investigations are neither rushed nor interminably delayed, affirming that both officers and the public benefit from timely and well-executed reviews. Additionally, some legislatures have considered introducing provisions that clarify the nature and extent of officers' representational rights during internal investigations. While POBR laws often guarantee that officers can have counsel or union representation during questioning, reform measures sometimes aim to ensure that this right is not abused to stonewall inquiries. Proposals might specify that representatives cannot instruct officers to refuse to answer reasonable questions or unnecessarily protract the investigative process. By refining these guidelines, lawmakers can preserve the right to representation, a cornerstone of due process, while discouraging tactics that impede the discovery of facts and resolution of legitimate complaints. Legislative reforms have also targeted arbitration clauses embedded in POBR frameworks. Critics argue that arbitration can lead to outcomes where officers found guilty of serious misconduct are reinstated due to procedural technicalities or arbitrators' inclinations toward leniency. In response, reformers advocate for legislative changes that limit the scope of arbitration or at least ensure that arbitrators are selected from diverse, neutral panels with no vested interest in favoring officers. Some bills have proposed that arbitration decisions be subject to review by external oversight entities or that certain types of serious misconduct be exempt from arbitration altogether, ensuring that officers cannot simply circumvent accountability through procedural maneuvers. Another dimension of legislative reform focuses on codifying public reporting requirements. Proposed laws may compel police departments and oversight bodies to publish annual reports detailing the number, nature, and outcomes of misconduct allegations, as well as demographic data about complainants and officers involved. Such reporting requirements serve multiple functions. They enhance transparency, enable policymakers to identify systemic patterns or trends, and inform community stakeholders about the status of police accountability measures. In jurisdictions that have passed such legislation, stakeholders have found that the availability of aggregate data can drive more informed debates about resource allocation, training priorities, and policy adjustments. In some states, legislators have gone as far as to dismantle or radically restructure the original POBR frameworks. Maryland's decision to repeal its long-standing law enforcement officers' Bill of Rights in 2021 and replace it with new statutes that emphasize transparency, community involvement, and clear disciplinary standards is a notable example. By reinventing the foundational legal architecture rather than tinkering around the edges, Maryland's reforms demonstrate that legislative bodies have the capacity, and under sufficient public pressure, the political will, to fundamentally reimagine the relationship between officer rights and public accountability. Although it is too soon to gauge the full impact of such sweeping changes, their enactment underscores the potential for transformative legislative interventions when public scrutiny and political consensus converge. Beyond state legislatures, federal involvement has also been suggested as a means of overcoming the patchwork nature of POBR regulations. Some reformers advocate for federal standards that set baseline requirements for transparency, data reporting, and investigative procedures, thereby preventing jurisdictions with entrenched resistance to reform from maintaining opaque or unaccountable practices. While federal legislation in this domain remains a subject of debate, its proponents argue that such action could ensure a more uniform level of police accountability across the nation, mitigating regional disparities, and ensuring that fundamental norms of fairness and transparency apply universally. Others caution that a one-size-fits-all federal approach might neglect local contexts and the need for flexibility in addressing community-specific issues. Still, legislative changes alone may not suffice to transform POBR systems if they are not accompanied by diligent implementation and enforcement. Reformers emphasize that effective legislation must be supported by adequate funding, training, and administrative capacity to translate statutory language into practice. For example, if a new law requires departments to release certain records, the agency must develop protocols to redact sensitive personal information, securely manage digital data, and respond promptly to public requests. Similarly, If legislative reforms broaden the authority of civilian oversight bodies, these entities must receive the resources, staffing, and legal mandates to perform their functions competently. Policymakers who champion legislative reforms recognize that the passage of new laws is but the first step. Their ultimate success depends on ongoing evaluation and adjustment. Skeptics of legislative interventions often highlight potential unintended consequences. Some argue that increased transparency could lead to unwarranted public pressure or media sensationalism, discouraging officers from proactive policing or cooperation in internal affairs inquiries. Others claim that narrowing arbitration rights might dissuade experienced officers from remaining in the profession, potentially affecting department morale and recruitment. Reform-minded legislators generally respond by emphasizing that these reforms are not zero-sum propositions. Rather than stripping officers of fundamental rights, well-crafted legislation aims to refine procedures so that they function as intended, protecting good officers from political manipulation and ensuring that genuinely problematic behavior cannot hide behind legal technicalities. The evolution of legislative reforms in this area suggests that the debate is dynamic and ongoing. As public attitudes toward policing continue to shift, and as more data emerges about the efficacy of accountability measures, lawmakers will likely revisit POBR statutes to reflect contemporary standards. Already, some jurisdictions that adopted incremental changes are evaluating their impact and considering further amendments. This iterative approach indicates that legislative reform is not a one-time event. Rather, it is a continuous process of learning, adjusting, and striving for a more equitable balance between officer protections and public accountability. In conclusion, legislative changes and reforms represent a pivotal aspect of the broader movement to update and improve POBR frameworks. By re-examining confidentiality rules, adjusting procedural timelines, refining arbitration mechanisms, and enhancing reporting requirements, policymakers are working to align statutory protections with evolving conceptions of justice and community expectations. Although resistance and challenges persist, the legislative landscape is increasingly attentive to the notion that procedural safeguards should not become barriers to meaningful accountability. Instead, carefully crafted legislation can safeguard officers' rights while ensuring that the public retains the oversight capacity necessary for a healthy, transparent, and legitimate policing environment. Role of civil society and advocacy groups. Civil society organizations, advocacy groups, and grassroots movements have played a crucial role in driving reforms to the Peace Officer Bill of Rights, POBR frameworks. Acting as intermediaries between the public, policymakers, and law enforcement institutions, these groups channel community concerns, gather research, and propose evidence-based solutions that seek to recalibrate the balance between protecting officers' rights and ensuring robust accountability measures. Their efforts are grounded in the belief that lasting change emerges from inclusive dialogues, data-driven approaches, and persistent engagement with the legal and political processes that shape policing standards. One of the primary functions of advocacy groups is to raise public awareness about the intricacies of POBR legislation and its impact on transparency and accountability. These laws, often seen as arcane or opaque, can be difficult for the average citizen to understand. Civil society organizations bridge this knowledge gap by explaining how POBR provisions affect the availability of disciplinary records, the timeliness of investigations, and the accessibility of key evidence during legal proceedings. Through public forums, educational workshops, research reports, and social media campaigns, groups such as the American Civil Liberties Union and the Leadership Conference on Civil and Human Rights translate legal nuances into accessible information, empowering communities to meaningfully engage in policy debates. The mobilization facilitated by civil society extends beyond awareness building. Grassroots organizations often organize community forums, town halls, and listening sessions in neighborhoods most affected by policing policies. By creating spaces where citizens can voice their experiences, frustrations, and aspirations, these groups ensure that reform proposals are rooted in lived realities rather than abstract concepts. The input gathered from these sessions helps advocacy groups formulate specific reforms to address issues like delayed investigations, unaccountable arbitration processes, or restrictive disclosure rules. As a result, the proposed reforms reflect genuine community priorities and carry moral authority when presented to legislators or police departments. Another important role played by advocacy groups is the collection and dissemination of empirical data. Reliable information is the backbone of effective policy reform. Without credible evidence of systemic patterns of misconduct, opaque disciplinary outcomes, or disparities in how complaints are handled, reformers would struggle to persuade skeptical stakeholders. Organizations like Campaign Zero and various think tanks have assembled national databases, analyzed complaint data, and produced comparative studies that highlight the correlation between POBR provisions and reduced transparency or accountability. By grounding their arguments in data rather than rhetoric alone, these groups strengthen the credibility of their reform proposals and build a more persuasive case for legislative change. Civil society also excels at coalition building. Realizing that shifting entrenched legal frameworks, such as POBR, demands a broad base of support, advocacy organizations forge alliances with unions, policymakers, faith leaders, academic institutions, and other community stakeholders. This inclusive approach fosters a more resilient reform movement. For example, when civil rights groups team up with organizations representing public defenders, victims advocates, or former law enforcement officials who support increased transparency, the resulting coalitions can present policymakers with consensus-based proposals rather than divisive demands. By demonstrating that multiple constituencies, ranging from reform-minded officers to citizen watchdogs, agree on certain modifications, these coalitions mitigate the perception that reforms are inherently anti-police or one-sided. Moreover, advocacy groups play a strategic role in the legislative arena. They lobby elected officials, provide testimony during legislative hearings, and draft model bills designed to address specific shortcomings of POBR statutes. Their continuous presence in policy discussions helps ensure that proposed reforms do not wither on the vine. Instead, legislative sessions become opportunities to refine proposals, incorporate feedback from various stakeholders, and adapt solutions to evolving political landscapes. Over time, repeated engagement on these issues can shift the legislative status quo, encouraging lawmakers to view increased transparency and accountability not as radical concessions, but as reasonable, expected components of responsible governance. Walker, The New World of Police Accountability, 2019. Civil society's role extends beyond policymaking and into the realm of oversight and implementation. Reform proposals, once enacted into law, must be effectively translated into practice. Advocacy groups monitor whether departments comply with new disclosure requirements, meet revised investigative timelines, or adhere to streamlined disciplinary procedures. They act as watchdogs, reporting on compliance, highlighting successes, and calling attention to backsliding or foot-dragging. Public interest litigators associated with these organizations may challenge departments in court if they fail to comply with reformed regulations, using legal avenues to enforce accountability measures enshrined in legislation. In addition, advocacy groups often serve as conduits for cross-jurisdictional learning. By studying reforms implemented in different states, analyzing what worked and what did not, and sharing best practices, these organizations help spread successful legislative models. For instance, lessons learned from California's incremental steps toward transparency, such as opening certain officer misconduct records, can inform reform proposals in other states. Similarly, Maryland's repeal and replacement of its long-standing law enforcement officers' Bill of Rights can serve as a blueprint for more ambitious overhauls elsewhere. Advocacy groups ensure that constructive policy innovations are not confined to one region, but contribute to a nationwide dialogue on accountability. Lastly, civil society organizations and advocacy groups contribute to cultural change within the broader policing ecosystem. By continually emphasizing that increased accountability can coexist with and even enhance effective law enforcement, they help recast POBR reforms as beneficial for both the public and conscientious officers. Over time, this cultural shift may reduce resistance to transparency measures and foster a policing environment that prizes integrity, responsiveness, and community trust. Through sustained engagement, advocacy groups demonstrate that reforms are not merely about curbing misconduct, but about building a policing model grounded in fairness, legitimacy, and shared responsibility. In sum, the role of civil society and advocacy groups in POBR reform movements and proposals is multifaceted and indispensable. Their efforts to educate the public, gather and analyze data, build diverse coalitions, shape legislative agendas, enforce new standards, and promote cultural change have collectively pushed the debate over police accountability beyond rhetorical clashes and toward meaningful, evidence-based discussions. As these organizations continue to work at the intersection of community voices, policymaking, and legal reform, they chart a pathway toward a future in which strong procedural safeguards for officers complement, rather than constrain, the public's right to transparent, accountable, and equitable policing.